can you give us a little bit of a lesson on how this works with a protective order that the defense in this case is pushing back on?
Well, sure, Joe. I mean, this is not about restricting anybody's First Amendment rights and their right to free speech. This is about the traditional practice and procedure in criminal and in some civil cases in the court of law. We try our cases in the courtroom, not outside of the courtroom. And especially in criminal cases, there is a large amount of discovery material handed out by the prosecution to the defense as they get ready for trial. And that information should be restricted, looked at, and held closely by members of the defense team, by the defendant, and by people assisting them. It shouldn't be used and waved around in public to rile people up, to push potential half-truths about certain statements that are made, and certainly not, as the government alleges, to be used as an intimidation factor against people who are either cooperating with the government or might be thinking of cooperating with the government. And so that's why in cases you get a protective order. And the order simply says you're going to be disclosed information. You're allowed to review it. You're allowed to share it with everybody on the defense team. You're allowed for the defendant to take a look at it, but it can't go outside of the defense camp. And it certainly can't be waved around in public.
Okay, so David, what happens from here then? We know that the defense doesn't like the proposal from the Justice Department, at least the initial one. So what's the recourse from here? Do we see it changed, or ultimately does it come down to the decision of the judge?
It comes down to the decision of the judge. She's now seen what both sides are asking for. There are a few points that they've actually agreed on, and so she will accept those. And then as to the rest, she'll draw on her practice and procedure on what is traditionally done within her courtroom, within the district, and she will fashion her own order that incorporates much of probably what the government has asked for.
So what's going to come next here, then, with regard to this case? We have others that we want to ask you about. They're going to be back in court later on this month, and they're going to be fighting a trial date. Does that need to be ironed out first? Because we've heard from the legal team on a change of venue, on a different judge. But that's the tactic, right? Delay, delay, delay.
That's been the tactic of this defendant in every case he's ever fought, whether it's a civil or a criminal case. But you're right, Joe. The next step is come into the courtroom, and the judge has asked for a suggested trial date. Right now, she has to set a date within 75 days of his arraignment. That's what the speedy trial rule calls for. Absent delay, which is substantial and which she finds is constitutional, she sets it within 75 days. And so she's given both sides time to come in and give her a schedule. And again, they need to come up with valid reasons for why they would like an extended delay, and for the prosecution, why it should happen quickly. And so they'll come in, she'll pick a trial date, and then from there, we'll see those motions that they talked about, potentially a change of venue, one to recuse her, although they have to have factual legal basis to ask for both of those.
Okay, so we'll look ahead to August 28th, which is that next hearing in this case in particular. But in between now and then, David, we could see another indictment coming down in Fulton County, Georgia, where the district attorney there, Fani Willis, is expected to unveil that, in theory, in just the coming weeks against former President Trump. And here's what Trump's lawyer, John Lauro, said on Meet the Press yesterday about that specifically. Take a listen.
What he was asking for is the Secretary of State to act appropriately and find these votes that were counted illegally. That was an hold on one second. That was an aspirational ask. He's entitled to petition even state government, but that doesn't involve an obstruction of federal government.
So, David, as a former prosecutor, does an aspirational ask hold up in court?
Well, that's one of the defenses that he's going to put forward. And, you know, whether it holds up in court or not is going to be up to the 12 jurors who they ultimately select, and whether or not that refutes the prosecution's theory of their case. Look, an aspirational ask is fine as long as you don't then follow up with what the government has said is a criminal conspiracy, where you're trying to coerce people to change the way that they would be acting under the law, where you're trying to propose, again, according to the government, fraudulent slates of electors. That's where it changes from an aspirational ask to something that's more criminal in nature.
Well, we're hearing a lot of things about this case, David, including from the sheriff in Fulton County, who says Donald Trump will be treated just like everyone else, and that will include a mug shot. I assume that that's in his purview. But what if Donald Trump decides that he doesn't want to do that? What if he doesn't show up? How would he be compelled to come to Georgia? And would that not include marshals from Ron DeSantis's state to bring him there?
Well, if he's in Florida and he needs to be arrested and brought to Georgia, then law enforcement in Florida would assist with that arrest. Perhaps U.S. Marshals would assist with that arrest. If he's in New Jersey and he doesn't show up in Georgia, then the authorities in New Jersey are going to be asked to assist. But look, if we're going to treat him like any other criminal defendant, then we should treat him like every other criminal defendant. He's served with a summons to appear, and you either honor the summons and you appear, or somebody comes out and arrests you and puts you in handcuffs, and then you get dragged through the system. So it would be in his best interest, whether he likes it or not, to voluntarily appear in Georgia state court. State courts operate differently than federal courts. They are mugshots that are taken that become public records. In the federal system, he did have a mugshot taken. It's part of the U.S. Marshals booking process, and there is a mugshot on file in the U.S. Marshals Service of Donald J. Trump. They don't release it to the public. State courts are different. You saw New York State decided not to release it. Who knows what will happen in Georgia?